Good morning. My name's Fiona McClellan. I'm a partner in the Dickinson Health Employment Department. I'm based in our London office. I'm joined today by my colleague, Michael Wright. He's going to introduce himself a little bit later on in the session. It's great to have you with us today for this webinar, which is part of Hill Dickinson's ICB Developing Picture series. Today's session is focused on the employment perspectives related to ICBs. So just to kick off in the traditional fashion now with webinars, a little bit of housekeeping. Just to facilitate the session today, everybody in attendance, their microphones are switched off and you're muted. If you have any issues with connectivity, with the sound or with the vision, there's some tips on the slide there. We also suggest maybe just logging out and logging back in. That might give you some better connectivity. Just to let you know, today's session is being recorded and it will be available for attendees and circulated after the event. If you have any questions, just to facilitate the flow today, we don't have a huge amount of time. We'd ask that you stick your questions into the chat box and then we can come to them at the end of the session, the Q&A session, which we're going to finish off with today. And then finally, your feedback is really important to us, so we'd really be grateful if you could take a couple of minutes at the end of the session just to give us some feedback and particularly tell us what you're interested in so that we can tailor some sessions that will be good for you going forward. So, what are we looking at today? Be helpful if I could get that slide to move on. There we go. So the agenda for today is, first of all, looking at workforce review and design, or perhaps redesign, better put, and also just a nod to some of the efficiency requirements that ICBs have. I'm then going to hand over to Mike. He'll be looking at effective collaboration and partnership working. And then we're going to finish off with a very, very quick horizon scan in relation to employment law developments. And we'll finish off, as I said a moment ago, with a Q&A session. Now, we only have an hour today, a little bit less with the Q&A session, to look at some pretty chunky areas. So the areas that we focused on, so the review, the reorg and collaboration, we think are the most pressing issues for ICBs at the moment, and certainly in terms of the advice that we're giving to ICB clients. But we do recognise that there are a myriad of other employment related issues and problems that you're also grappling with. So we're not ignoring them. We recognise that, you know, the perennial issue of recruitment and retention and reward, etc., and also culture, organisation development, and factoring into that some of the big ticket areas, certainly central pillars in the NHS people plan, so equality, diversity and inclusion, staff health and well-being. But those topics all, you know, taken individually could take up all the time we have today. So we recognise that you have those to deal with as well, but we think the redesign, the efficiencies and the collaboration are the bigger ticket issues for you at the current time. So, starting off with workforce review, redesign, planning and your efficiency requirements. So, at the risk of stating the obvious, workforce review and design is broadly speaking about seeking new ways of working for you and your existing staff. And within that, you're ideally going to be developing their skills and at the same time meeting the goals and the needs of your organisation. And also in this context, your new organisational systems and processes, and that's going to span across your system and working in partnerships with other organisations to prioritise and improve patient care. Now, ICBs are, of course, already in the midst of reviewing and workforce planning following their establishment last year. And having had a bit of time now to map out operationally and strategically what they need to do now, what they need to be doing in the near future, and taking stock of what they've inherited from the previous system setup. So feeding into the mix, what kind of things, if you're not doing them already, are you going to need to do in terms of your workforce review and planning? Well, ordinarily, this process will involve, first of all, a careful and detailed due diligence exercise of your current workforce. The purpose of that is simply put to ascertain the staff that you have, so the types, numbers, their skill set, their location being key factors in workforce planning, and then to map against that stock take that you've done what you think you're going to need going forward. And the going forward piece will be immediate future considerations, but good workforce planning usually will build in some future proofing. So looking at what you consider you're likely to need longer term. So the key questions that ICBs, I suspect, are already asking, but may need to be considering again in the face of the financial efficiencies that you need to meet are set out on the slide there. So just to highlight, these are people focused. So this is sort of premised on the basis that you've already undertaken your mapping out, your analysis of your statutory, your operational, your partnership requirements. You've got that framework in place, and then the workforce planning, review and design is just another piece of the jigsaw puzzle to map out the direction of travel for the organisation going forward. So you'll be asking questions about the kind of staff that you need, the numbers, the skill sets. Importantly here, thinking about working across systems, where you need those staff to be, what flexibility you have in terms of location and facilitating flexible working. That's absolutely central to collaboration that Mike's going to be looking at. And also, again, it's another one of these golden threads that runs through the people plan, facilitating flexible working. What current terms and conditions do you have? What terms and conditions have you created? What ones have you inherited? Do they assist you in a workforce review and redesign process? And if they don't, are you able to? And how do you go about changing those terms and conditions to take you from A to location B where you need to be? And building into all of this, how do you deal with the expected efficiency requirements that ICBs now have? And is your process, and again, this is part of your mapping out and creating your framework for the process to redesign, are you going to have to reorganise? Will that reorganisation involve dismissals? Will those dismissals constitute redundancies? Because from an employment law perspective, there are certain important statutory processes that you need to get right. Otherwise, there are significant liabilities for the organisation. And then surrounding all of that is staff engagement is completely essential to get the buy-in from staff and be able to support them in a review and change process. I think all employers recognise and understand, often from bitter experience, that without the staff engagement, you can end up in a difficult place affecting change. Best case scenario, complaints and grievances, worst case scenario, litigation. So a variety of different things to be thinking about and a good checklist to keep coming back to as you're going through a review process. So I've mentioned expected efficiencies a number of times, and they are going to be front and centre of the ICB workforce planning and redesign process. And that's because all ICBs, so the chief executives, regional directors, financial directors, were sent correspondence from NHS England at the start of the month, so 2nd of March, setting out the longer term expectations in terms of running cost allowances. And that longer term expectation relates to the next 3 years, so up to 25, 26. Now, the key terms of that correspondence, the writing's quite small, so it's quite dense. I'm not going to go through it all because it does what it says in the tin, and you can take time to sort of read it and look at it subsequently. But if you extrapolate from those points on the slide, absolutely central to these expected efficiency requirements are workforce and the associated costs, and also the need for more effective collaboration and partnership working. So, going full circle on what we're looking at today. What are the running cost allowance expectations? Well, they're set out on the slide, and they're pretty chunky. So 30% real term reductions by 25, 26, and at least 20% of that has to be delivered by 2024, 25. So that's going to be a massive driver now. And as I say, front and centre of the workforce review, planning, redesign that most ICBs already have underway. Just to flag, in the letter, NHS England do signpost the support that their regional teams can provide in terms of implementing the changes that will be required to achieve these efficiency requirements. So that can include providing benchmarking information, examples of good practice in reorganisation and sharing functions. So as I say, that's going to be an important part of the ongoing review and redesign process. So turning now to more sort of employment law focused side of things. I'm an employment lawyer, so not much of a surprise. I want to focus on that. What does all of this requirement for review and redesign and meeting cost efficiencies, what does that mean in terms of employment law implications? Well, there are a number of different things that you're going to have to factor in and take careful note of in your redesign mapping, your planning, your process, and then when you're effecting the changes that need to be made. And the first part of that, it seems to me, has to be looking at the terms and conditions of employment that you have. Now, that's because you will have inherited terms and conditions of employment from the previous system, and you'll have to have careful consideration of those. They might not be overly familiar to you. They might contain helpful flexibility. They might not. They might contain unhelpful terms. So again, it's a bit of a due diligence exercise on the terms and conditions. In terms of ascertaining what the terms and conditions are, yes, obviously you need to look at contracts of employment of the staff that you have, and the local terms and conditions of employment that you may have created for your ICB, and potentially the terms and conditions of any organisation with which there's going to be collaboration, integration and partnership working. All of those can be relevant. And just a reminder that the employment terms can be set out in a number of different places. It's not necessarily just a case of looking at the employment contract. So yes, the express terms of an employment agreement will be contained in the employment contract, which has been signed, entered into between the parties. But there are also implied terms in employment contract, the one that we hear about all the time, the implied duty of trust and confidence. But other employment terms can exist and be implied through custom and practice. And terms can also be incorporated through statute, collective agreements, and other contractual provisions. So just important to do a complete review to make sure that you've factored in all of the relevant terms and conditions. You're likely to be looking for provisions that help you to redesign and reorganise. So some inherent express flexibility within the contract. Just a note of caution about placing an over-reliance on any express flexibility within an employment contract. And the reason that I flag that is because of the principles of contract interpretation. And they say a number of things. But in this context, just to be mindful of the fact that where there's any ambiguity in a contract, it's going to be construed against the employer as the stronger party in the relationship. So in favour of the employee, where there's ambiguity. Specific flexibility clauses we know from case law are likely to be given a restrictive interpretation by the courts, and they may be constrained and limited by implied terms that any flexibility is exercised reasonably by an employer. The court, you have to bear in mind again this implied duty of trust and confidence, because that tends to mean that the courts will require any contractual discretion to be exercised in good faith and in a manner which is not arbitrary, capricious, or irrational. The key takeaway here is employers are unlikely to be able to make substantial changes to contract terms, and certainly not ones that are detrimental to employees, placing reliance on general flexibility provisions in a contract. So ones that relate to an employee's duties and their location and mobility, I think, are likely to be particularly key for ICBs in thinking about working across place and different systems. Changing terms and conditions of employment, except by agreement, should not be undertaken lightly. There are a variety of different risks and challenges, particularly in circumstances where you have to consult and agree on changes with recognised trade unions or other employee representatives. So I would say if you're looking at changing terms and conditions other than by express agreement, you're approaching it with that sort of amber light, you're approaching it cautiously. And if you are getting into a scenario where you're thinking about imposing changes unilaterally, so I've set out on the slide the ways in which you can change terms and conditions, but in the last two bullet points there, unilateral changes in the hope you can rely on the employee just accepting them, not challenging them. Or where you decide you can't get agreement with employees, with recognised bodies, and you want to dismiss and re-engage to hire the staff back on the new terms and conditions that you need, that's a red light. That's a stop, reflect, and take advice. And the reason that I say that, particularly in relation to dismiss and re-engage, is where that process impacts on 20 or more employees, it triggers the statutory collective consultation framework. And if you get that wrong, you can be facing a protective award claim, which is effectively a penalty of up to 90 days uncapped pay per affected employee. Protective award claims start to look really chunky really quickly. So if you're in the unilaterally imposing, dismiss and re-engage, that really is stop, take time to think about what you're doing, what you need to achieve, and take advice. And then finally, as if there wasn't already enough to think about, just something to be aware of in this particular context in which you're operating, is the fact that you're likely to have some constraints in terms of changing contract terms for current staff because of the background in which they came to you, in which you inherited them. And NHS England's employment commitment as part of the creation of integrated care boards. A lot of staff moved in on the basis of CHUPI transfers or CHUPI-like transfers, so COSOP transfers. And CHUPI, as you probably know, protects against changes to terms and conditions for affected staff for an indefinite period where the sole or the principal reason for the change is the transfer. So where there's a CHUPI or a CHUPI-like backdrop, changes to terms and conditions will be void, even if the employee agrees to them, in circumstances other than where they're unrelated to the transfer, or where they're for an economic, technical, or organisational reason entailing changes in the workforce. That's the big tick here. That's the one you're likely to be relying on, a restructuring, a reorganisation situation, where the changes are permitted by the contract, or where they're incorporated by a collective agreement. So there's a lot to think about in that first part of the stock take, looking at the terms and conditions of employment. Moving on then, just to look quickly at reorganisation and then redundancy, because these are the obvious knock-on effects of a review, a redesign process. So what do we mean by reorganisation? Reorganisation in employment law terms is one of these helpfully, unhelpfully nebulous concepts. It doesn't have a statutory definition. So it effectively covers any situation where you're making changes to the workforce, the way that staff are working, the model that you're operating, and that change doesn't constitute a redundancy. So you're in this sort of zone where it's, as I say, it's all a bit nebulous. Reorganisations may involve dismissals, but then again, they might not. They might just involve changes to terms and conditions, so all the stuff that we've just looked at. Where there's a dismissal in the context of a reorganisation, so one where it's not a redundancy situation, you are likely as an employer to be able to rely on the potentially fair reason to dismiss of some other substantial reason. So you may be familiar, and this is all about guarding against unfair dismissal claims, which is it's the big risk when you're terminating an employment contract. In order to be able to defend an unfair dismissal claim, and these can be brought by employees that have 2 years or more continuous service, the employer has to, first of all, be able to point to a potentially fair reason to dismiss. So that's things like conduct, capability, redundancy. And then there's this catch-all, some other substantial reasons. So if it doesn't neatly fall into one of the other sort of more easily understood categories, you can rely on SOSR. And a reorganisation that's not a redundancy is likely to be an SOSR dismissal. What does that mean? Well, put simply, the second part of the unfair dismissal protection is potentially fair reason and effecting that dismissal, that termination, in a reasonable and fair way. That means having a process. Now, because reorganisation and SOSR are quite nebulous concepts, there's no prescribed process that would be a fair SOSR process. It's dictated by the particular circumstances. But I would have thought here, the circumstances are likely as a minimum for a process to be fair and to allow you any chance of defending an unfair dismissal claim, if it includes some form of communication with staff and engagement. So information out, allowing the employee the opportunity to respond, holding at least a meeting, if not a couple of meetings, with the affected employee or employees before you make a decision, and then offering a right of appeal. That's absolutely a basic minimum requirement. Really important to have the meetings and the right of appeal, because an SOSR dismissal is likely to be caught by the ACAS Code of Practice. And if you don't follow the minimum requirements to meet with staff before you make a decision and offer an appeal, and they are successful in a claim, they can receive a 25% uplift in any compensation awarded by an employment tribunal. And then finally, just looking at redundancy. Now, I promise this is high level. You don't want a detailed technical lecture on redundancy legislation, I'm absolutely sure. Redundancy is a highly probable outcome of a wide-ranging review and redesign process, particularly in circumstances where you have to make quite substantial efficiency savings, as we've outlined you have to do here. So when is there a redundancy situation? So I've set out in summary terms on the slide there the statutory definition of redundancy, which is enshrined at section 139 of the Employment Rights Act 1996. So circumstances where a business or part of a business is being closed. That seems unlikely in this context. Much more likely where there's going to be a reduction in need for a number of employees of a particular kind, or a number of employees at a particular place, or a number of employees of a particular kind at a particular place, all of those will constitute redundancies in a statutory sense. So if you are ticking the Section 139 box, what do you then do to carry out a fair redundancy process? And there are two aspects to this. First of all, if we think about it in the context of unfair dismissal claims, that's the most obvious risk if the employee has qualifying service. So how do you effect a redundancy fairly to assist you in defending an unfair dismissal claim in this context? Well, the leading authority is Polkey. And what this very well established case tells us, and the cases that flow from Polkey, is that as a bare minimum for a fair redundancy process to take place, an employer must properly look at selecting the employees who are potentially redundant. So that's putting them into appropriate selection pools by reference to the roles that they do, interchangeable skills, that sort of thing. And then once you have properly and carefully decided what your selection pools are, you then have to apply objective and non-discriminatory selection criteria to the individuals in those pools. So you're effectively scoring the staff who are affected by virtue of their role, their skill set, to work out who are at risk of redundancy. So that's a starting point. There then has to be an effective consultation process. So this is in the individual context. And this will require, again, as a bare minimum, consulting with staff at a formative stage, so before you've made definitive decisions, entering into the consultation with an open mind and a willingness to be persuaded that there might be an alternative route to the proposed redundancy route, giving the affected employees adequate information on which to give you their feedback and give them an adequate time to respond. And then you have to obviously consciously give consideration to the responses that you receive. You're not just paying lip service to the consultation process. And then finally, Polkey tells us that employers have to look for, and if they locate, put forward suitable alternative employment as a means of avoiding redundancy situations. And the suitability of alternative employment when an employer is looking for different roles is based on an objective test. So you're looking at what the affected employees do at the moment and what the new job or role would look like. So that's all the sort of the stuff you might expect in terms of the banding, the salary, the roles, the responsibilities of the roles, management requirements, career prospects, all of those sorts of objective things to do that comparative exercise. So that's the individual redundancy process for the purposes of guarding against unfair dismissal claims. The next thing that you have to consider potentially is whether or not you've triggered the collective consultation redundancy requirements contained in the Trade Union Labour Relation and Consolidation Act 1992. That just rolls off the tongue. Those provisions are triggered where 20 or more redundancies are proposed in one establishment across a 90-day period. And in those circumstances, the employer has to carry out a consultation process for at least 45 days before it makes the first dismissal, where 100 or more employees are affected. I think that's unlikely to be relevant in these circumstances. More likely, you're looking at between 20 and 99 redundancies, in which case that consultation period is 30 days before the first dismissal can take effect. Collective consultation, unlike individual consultation, requires the employer to consult with recognised bodies that represent the employees. So in this context, recognised trade unions. Where you don't have a recognised trade union, you will have to put in place an employee representative body with whom you can carry out the consultation process. That's likely to be most relevant for sort of more senior management groups that won't necessarily be covered by the recognised trade unions. As a minimum, the legislation requires this consultation process to be undertaken with a view to reaching agreement on the ways and means of avoiding dismissals, reducing the number of dismissals, and mitigating the consequences of the dismissals. And the legislation says that the employers have to, as part of the consultation process, explain the reasons for the proposed dismissals, the number and description of employees whom it's proposed will be dismissed, the method of selection, and the process that is going to be used to effect that dismissal process and the time period across which it will be carried out. And then finally, the methodology for calculating any redundancy payments. That's pretty straightforward if employees are engaged under AFC terms, because it's set out clearly in those national provisions. Collective consultation is not a substitute for the individual consultation. If the collective consultation obligations are triggered, you have to factor that into your process. It might actually help you with your individual consultation, but you have to do both, because the consultation collective and the individual consultation process that I outlined on the previous slide are to assist you in defending the organisation against different claims. So collective consultation, protective award claims, and the individual consultation process, unfair dismissal claims. That was a very, very quick canter through workforce redesign. I'm now going to hand over to Mike, who is looking at collaborative working models.
Thanks, Fiona. My name is Michael Wright. I'm a partner in the health employment team. I'm going to speak to you about collaborative working across place and working with other organisations. In relation to my background, in relation to this, I've sort of supported the reorganisation of NHS England in the past, worked with sort of NHS Trust reorganising, but I've also been recently working with some ICBs on this issue, and hopefully I'll draw down some of that experience as we go through. So this section is kind of looking at this issue from a different angle. So Fiona's set out the legal construct behind what is and what isn't possible, what are the legal requirements in relation to reorganisation and change. But I'm going to look at it from a different angle, drawing on some of my experience of working with sort of large organisations in your field, going through a similar situation. And I think, first of all, as Fiona mentioned, it's important to understand where you're at with your workforce. If you are looking to reduce your workforce or work collaboratively with other organisations, you need to understand where you're at. And I worked with NHS England about 5 or 6 years ago on this, and we developed these concepts of aligned, assigned, transfer, and seconded. And that was about looking where the organisation was at, because it was it had employees that were working in many weird and wonderful ways across different organisations, CCGs at the time, NHS trusts, and it wanted to understand how it was working, what was the risk in the way that was working, and what steps could be taken to mitigate that risk. How should their employees be working with other organisations? And aligned effectively meant that, well, we should retain management of this member of staff, but their job description should be focused on working across place. Assigned might be slightly different, where you say, well, this person would be better off working with others from an NHS trust or wherever it may be, primary care network, and we should have a job description that reflects that. It should say, you know, you will be working with these people, you may be managed on a day-to-day basis by them, but we will retain overall control. Transferred, we might be looking at a similar sort of situation, but saying, actually, we've delegated our function here or outsourced this service to this NHS trust or whatever it may be, organisation, and really that member of staff should transfer to them under 2P or the Government Code of Practice on transfers in the NHS, also known as COSOP, that Fiona mentioned. And then seconded, as I think seconded is quite well recognised, but I'll talk about it in a moment. It's basically saying, well, this member of staff would be better seconded to that organisation to work with them. So we'll retain their overall employment, but on a day-to-day basis, they should have control of that individual and a certain degree of responsibility. And that's to such a degree that we need to set it out in a secondment agreement. So as a starting point, I think it's useful to understand, I know that ICGs have been created relatively recently, and it may be in a position now to review the workforce, how they're working, who they're working with, how should they be working. And then once you're in that space, once you've worked out what your structure should look like and how people should be working across place and with other organisations, other NHS trusts, then that's the point at which you can sort of tap into some of the employment models I'm going to talk about now. And they are secondment agreements, workforce sharing agreements, MOUs, memorandums of understanding, licenses to attend, and then another final concept that I did a lot of work with NHS England on, which is joint appointments, where the same person is simultaneously employed by two or more organisations, and I'll go through the reasons why you might select that and some of the pitfalls, etc. So I think secondments agreements are generally well understood, and they're commonly used in the NHS. But just as an overview, and it's important to understand that it's basically saying, here's our employee, you now take control of him. They can work with you in your organisation, but we will retain the overall management of this employee from a high level. So if they want to submit a grievance, or for example, carrying out an annual review, that's what we will do. But on a day-to-day basis, telling them what to do, getting them to produce work for you, that's under your control. And often you will enter into a secondment agreement that might be a three-way agreement between your organisation, the organisation where they're going, and the individual, but it's all clear and people understand who's doing what and who's responsible for what, and there's that ability to apportion liability. In the awful event that there's, for example, discrimination arises, who's going to pick up the liability for that? How will it be managed? Or if it's a clinical role, how's the clinical risk going to be managed there? But it can give you a significant degree of flexibility over those issues. But it's clear under a secondment agreement, you're saying, over to you. This is our employee, and we're kind of lending them to you for the period of the secondment. So there is an understanding that they will come back to your organisation at the end of the secondment. I think the big risk of secondment agreements is people tend to get forgotten about. The over to you happens, but there isn't that degree of carrying out the employer carrying out the annual appraisal or retaining any sort of degree of control over the person. And the risk is, if this secondment agreement runs on and on and on, there's a risk that over time they've just become part of where they're seconded to their workforce, and there could be an argument that they're now being employed by that organisation. It's that creep has happened over time, because if they've seconded out of the ICB to this organisation, it hasn't been managed well and there's been no contact, etc. So if you are going to have these secondment agreements, then these reviews need to be built in. But you can see it can give you a degree of flexibility of outsourcing your staff for other people. One thing we've been doing recently with some of the ICBs is creating workforce sharing agreements across the patch. These can be really, really useful, and it can be an effective way of managing staffing demands across your region. On a whole host of staff, it could apply to anybody from clinical, non-clinical, managerial, HR, whatever it may be. And a workforce sharing agreement is basically, in its essence, saying, look, we understand there may be peaks and troughs of high demand, or one of the organisations in our region, and maybe an NHS trust may have a big demand to carry out a big project. And what we have here is a very basic framework over how that will be managed. So us as a group, that might be the ICB and all the NHS trusts in the region, are entering into a framework agreement to say, if we want to share staff, if we want to have staff working across our organisations, here's how it will be managed. So it's quite high level. It could include all types of staff, from clinical to managerial to whatever, or it could be simply focused on clinical and you have a separate agreement for that and a separate agreement for non-clinical. But it sort of teases out all those issues and gets them agreed in advance. Issues such as indemnity, as I mentioned before, with the secondment agreement, management, data sharing, that can go in there, that sort of stuff. But it's a relatively straightforward agreement to produce, but it's thinking about this in advance. And it's about saying, if we need to do this, if we want to do this, we can now draw down on this framework agreement that we've agreed amongst us. Part of the sticking point can be if you have staff being shared outside of the NHS. So if you want to include local authorities in that, or private sector or third sector organisations, simply because particularly with clinical staff, it gets a bit more complex about how you manage the clinical risk there and the involvement of NHS resolution cover, etc., etc. But it is relatively straightforward to look at a workforce sharing arrangement amongst the ICB and the NHS trusts in the region and any other NHS organisations. And like I say, we have put those in place, and it does give you a degree of flexibility. So obviously, if you are going through a period of reorganisation and you have to reduce your workforce, it helps. You're getting more out of your workforce in that way. And one thing that goes along with that is a sort of license to attend. So like I said, you'd have this workforce sharing agreement, the sort of overview of how this is all going to work. We've agreed it between us. But it doesn't say it must happen. It's there for you to draw down on. And if you then agree that this group of clinical staff will move from this NHS to this NH trust, or you will have a group of administrative staff moving from the ICB to an NHS trust to work together with other people, then you draw down on that overall framework. But you might need this license to attend. That's almost like the individual agreement between where they're going to work and the individual to say, well, what are the rules of them being on site at that, for example, NHS trust. So if it's a clinical member of staff, you might need some overall agreement about, dealing with allegations of clinical negligence. And for most staff, you'll need, well, how are grievances going to be managed? How long will they be going across? What are they allowed to do on your site when they're there? That sort of thing. So it's quite a simple agreement to produce. So, they work quite well together, the workforce sharing agreement. And then when you have times when you want to have staff shared between the organisations, you have the license to attend. And kind of separate from that is another concept, like I say, I developed with NHS England, and it's joint employment. So we have had situations where accountable officer is a good example, where you need your accountable officer that's within the ICB, and also they want to retain a role with a local authority, a quite significant role. To carry out both roles, the statutory framework or the governance framework for the organisation said they must be an employee of that organisation. So if that role can't be divided up, if you can't say, well, we'll do 3 days in this role and 2 days in that role, if it needs to be a joint working arrangement, you can have this concept called joint employment, where the same work, they're employed by 2 employers or more at the same time. That's usually covered in one 3-way agreement between the 2 employers and the individual. Both employers will legally employ that individual. It doesn't necessarily need to be for a fixed period. It could be, this is your job. And then really the agreement that you would enter to will deal with things like managing the employee, dealing with conflicts, dealing with the liability position, and whose grievance and whose policies, like grievance policy, who's going to discipline this individual. But again, it's possible to create, and it's not too troublesome. I am aware of clients where we've done this for quite a number of clients, and I haven't been aware of it causing any practical issues, really. It tends to be aimed at quite high level individuals, board level. And if you recall the white paper from 2021, which sort of led to the creation of the ICBs, did talk a lot about joint employment and joint working at the highest level. So again, it's something we can prepare, and it doesn't create too much of an issue. So just to recap on my section before I hand back to Fiona for the final section is, I would recommend, if you are going to carry out big reorganisation or a big piece of work looking at collaborative working, you need to understand where you're at now, how you want to work. Do you want to transfer a load of staff here, or do you want to retain control, or do you want them seconded there? Then once you have decided how you want to work, the legals behind it and the agreements behind it aren't too difficult to achieve. I think there's a great deal of flexibility in the way we can have people working. Obviously, we'll need people to be aware of that and agree to it, the people that are transferring. But I think sometimes people perceive issues like how we're going to deal with the management of clinical negligence, when the reality is that can be managed quite readily. So that's what I've got to say about collaborative working. So I'm just going to hand over to Fiona for the final piece. Thank you.
Thanks, Mike. So just finishing off with a quick employment law horizon scan, just having a look at things that are likely to be relevant to your organisations, to ICBs, in the very near future, and then a bit of a further scan to things that are likely to be coming in. So first of all, something that's imminently on the cards for ICBs relates to the publication of equality information and also the gathering together of data to produce gender pay gap reports. So the context for all of this is that recently the Equality and Human Rights Commission wrote to all ICBs to confirm that the deadline for those organisations to publish equality information and objectives is the 30th of March this year, so a couple of weeks away. I would have thought that will all be well in hand, but if it's not, definitely a time to strap your skates on and get cracking in pulling all of this information together. So what the Equality and Human Rights Commission have confirmed is that ICBs are now one of the organisations listed in some regulations from 2017. And those regulations necessitate the named organisations to do a number of things. So first of all, they have to publish equality information. So that's information that demonstrates their compliance with the public sector equality duty. So effectively what that means is that ICBs are going to have to be transparent about the work that's been done and is planned in terms of equality, diversity and inclusion to demonstrate how it's meeting, that ICB is meeting the requirements of the public sector equality duty. So that's the first part. And then there's also a requirement under a different regulation within these statutory provisions to publish equality objectives. So they're the goals that the organisation considers that it needs to achieve to comply with the public sector equality duty. So the equality information, the objective information, has to be published by the 30th of March this year, and thereafter the equality information needs to be updated annually, and the objective information every 4 years after the first date of publication. So some pretty significant imminent deadlines in terms of equality and diversity information. And in addition to that, ICBs have to, in order to be able to comply with their obligation, if they have 250 or more staff, to publish gender pay gap report information. They have to publish that by the 30th of March next year. But in order to be able to comply with that deadline, the ICBs that are caught, so those with 250 or more staff, have to collate all of the relevant information for the reporting by this March, so the 31st of March this year. That's what they call the snapshot date. You're looking at all of the information covering the workforce profile at that date. And the gender pay gap reporting, just to sort of cover this in case you're not familiar with it, the information that you have to report are the percentages of men and women within the organisation, split into 4 equally sized groups ranked from highest to lowest. And within that ranking, you're providing information of the average, so the mean gender pay gap for hourly pay, and the median gender pay gap for hourly pay. And then you've also got to report on any bonus payments, the percentage paid to men and women, and again reporting on the average, the mean gender pay, bonus pay, and the median gender pay, bonus pay. So some quick work to be done in relation to meeting those statutory obligations, and that compliance is monitored by the Equality and Human Rights Commission. So important not to get that wrong, because there can be implications. And then this sort of slightly wider gaze out into the potential future employment legislation. So I've picked out the bills that are currently going through the legislative process that I think are of most relevance to ICBs, indeed to any organisation that's operating in the health and social care sector. What we've got is a raft at the moment of private members' bills. So several years ago, sort of pre-pandemic, the government had been promising to implement an employment bill. And that's pretty much now dead in the water. That was confirmed by the government at the end of last year. And what it said it's doing instead is sponsoring a number of private members' bills that cover the same ground. So the ground that was going to be covered in the employment bill. These, as I say, are all going through the relevant sort of parliamentary stages. The anticipation is that we wouldn't get the legislation if the bills are passed until next year, so 2024. So what is this legislation that's on the horizon? Again, interesting, I think, because all of it ties back to pillars, strands within the NHS People Plan. So all likely to be quite significant as part of your building flexibility, supporting staff with their particular caring, family-friendly requirements. So first of all, the Protection from Redundancy Bill, if this is passed, it will enhance the rights of staff on maternity leave, staff taking adoption leave or shared parental leave, to be given preference for suitable alternative employment in redundancy situations throughout the period of their leave and for 6 months after their return to work. So it's adding on that additional 6 months protection and going to the front of the queue in redundancy situations for suitable alternative employment. Carers leave. If this bill is passed, then eligible employees will be entitled to unpaid carers leave for at least 1 week in every year for the purposes of caring or making preparation arrangements for the care of a dependent that has long-term care needs. So a dependent would be a spouse, civil partner, a child, a parent. That legislation will have inbuilt into it protection against detriment and or dismissal for seeking to utilise the right to carers leave. We also have a neonatal care leave and pay bill that's going through the parliamentary process. If passed, this bill will give parents of a child who is receiving or which has received neonatal care an entitlement to a minimum of 1 week, and we believe it's going to be up to 12 weeks of neonatal care leave, and that can be taken up to 68 weeks from the child's date of birth. It's going to be a day one right, and again, it will have built into it protection against detriment and dismissal for exercising the right to take the leave. In addition to the ability to take the leave, there is an entitlement to pay, so paid leave for staff with 26 weeks or more service, and the level of pay will be at the prescribed rate. So that's the same rate or a statutory maternity pay, adoption leave pay, etc. And then finally, some changes being proposed to the flexible working legislation. I've put out the key things on the slide there. I suppose the most significant ones to note is the ability for employees, if this legislation is passed, to make 2 requests instead of 1 a year. Employees don't have to explain what they think the consequences of their request would have on the employer. That's part of the current regime. There would also be a requirement on employers to consult with employees before rejecting a flexible working request. And the timescale in which to consider a flexible working application will reduce to 2 months. It's currently 3 months. Just a word of caution, because I've seen this coming up in a couple of cases for clients recently. If you in-build, and most NHS organisations in my experience do, if you in-build an appeal aspect to your flexible working process, the time frame of currently 3 months or 2 months will include that appeal process. And that a couple of employers I've seen get burnt by that recently. So you've got to have started and completed right through to giving an appeal outcome within the time period. And then finally, we've got a bill about worker protection, specifically third-party harassment. So for reasons not entirely clear, third-party harassment protection was taken out of the Equality Act when it was created in 2010. So that's now going to be put back in. So this bill, if passed, will place an obligation on employers to take reasonable steps to prevent employees from suffering harassment in the course of their employment at the hands of third parties. So clients, patients, agents, etc. It's also going to create a new duty on employers to take all reasonable steps to prevent sexual harassment in the course of employment. And if an employer is found not to have taken said reasonable steps, and an employee is successful with a sexual harassment claim, they can be entitled to up to 25% increase in any compensation that's awarded. And just something to flag about this bill, the government has introduced a last-minute amendment to it, specifically to say that employers won't be liable for workplace harassment, excluding sexual harassment, where the harassment relates to a conversation in which the complainant didn't take part, and in that conversation, opinions are expressed on political, social, moral, or religious matters, provided the opinion isn't grossly offensive and there is no intention to violate dignity. So we're talking here about overheard conversations in which personal views are expressed, all very interesting, I think, in the context of another hot topic in employment law at the moment, which is gender identity and gender critical views. But what does all of that mean practically with this amendment? Well, there's going to be new protection against third-party harassment. They're bringing that back in. A duty to prevent sexual harassment with a penalty for failing to do so, but a weaker form of protection in a non-sexual harassment context because of this amendment. So that was a very quick look through some imminent employment provisions relevant to ICBs and what's on the horizon. I think we've got time. We've got a few minutes left for any questions that anybody has. I'm just going to check the chat box to see if we've got any questions. Not seeing anything so far. If anyone has a burning question, now is your time. We've stopped the recording, so you can feel free to express your views. Happy to take any questions at all, and perhaps if you want to raise your hand rather than sort of typing something out. Oh, I can see a hand. Hi, Tom. Do you want to unmute yourself, or can one of my helpful colleagues in marketing unmute you and you can ask your question?
Well, yeah, I think I'm unmuted now. Thank you so much for the presentation. I was wanting to go back to the point, I think really near the start, we talked about terms and conditions,